SJC-11885, Maria A. Kitras and others v. Town of Aquinnah and others.
Good morning, Ms. Roberts. I guess we have 5 attorneys arguing this case, huh?
We do, Your Honor.
Okay, okay. It's like a basketball team. Okay. You may begin. Thank you.
May it please the Court, Jennifer Roberts, on behalf of the defendant, Vineyard Conservation Society. My colleagues and I submit that the majority opinion of the appeals court, relying on a novel theory of the law, which has been embraced by no one in this action, including the plaintiffs, should be rejected, and the decision of the land court should be affirmed. I'm going to spend 5 minutes of our time this morning with respect to how the common law of Massachusetts deviates from the restatement and why this court should not adopt the restatement. Ms. Tillotson, on behalf of Martha's Vineyard Land Bank, is going to discuss why the common law presumption underlying easements by necessity does not apply on the unique facts of this case. And Mr. Rappaport, on behalf of the town of Aquinnah, is going to spend the final 5 minutes discussing the impact of the appeals court decision on the town. So turning to section 215 of the restatement, it deviates from Massachusetts common law in 2 significant ways. First, it's based on, at least in part, on a public policy against landlocked parcels, which is a public policy that was rejected by this court almost 125 years ago, and which has been the subject of recent criticism. Secondly, it shifts the burden of proof from the proponent seeking access to the owner of the estate sought to be encumbered. With respect to the burden of proof issue, Massachusetts law is replete with cases which have emphasized that the proponent of an off-record easement carries a very heavy burden. The burden is squarely on the proponent, and it is a heavy burden. The reason for that is clear. Many millions of dollars worth of real estate is conveyed, changes hands in the Commonwealth each year, and that part of the economy functions in large measure because the Land Recording Act and Registration Act give sellers can know based on those acts what it is that they have to sell and can properly value it. Buyers, as a result, know what it is they're buying and can properly value what to pay for it. So anytime that off-record rights are either recognized or expanded, it has an adverse impact on the important goals embodied in the Land Recording and Registration Acts, which are to promote certainty of title, so that which is a cornerstone of land transactions in the Commonwealth and a cornerstone of the state's economy. It's a very important public policy. In contrast, the public policy recognized by the restatement, which is against landlocked parcels, I would, in addition to this court having already rejected that as a basis, I would refer you to the law review article cited by Justice Agnes in his dissenting opinion, which outlines a number of problems with the public policy theory as an underpinning for easements by necessity. I'll highlight just one for you. The restatement focuses exclusively on the burden on the proponent seeking access. It pays no attention at all to the burden that's about to be placed without any compensation on the owner of the estate that's sought to be encumbered. That alone, I would suggest, would satisfy, this court should satisfy this court that it's not a public policy that this court should embrace.
So before you get too far, tell me what you say should be precisely our rule with regard to landlocked property.
The reality of that, I mean, I don't think the rules should change because it seems to have worked well for the last several hundred years. At this point...
And how do you characterize what you say to be our law now?
I'm sorry?
How do you characterize what you say to be our law today?
The law today is that off-record easements, easements by necessity, are only recognized in the rarest of circumstances when there is clear proof that that was the intent of the parties at the time of the grant, that that right be granted. I should note to the court that the actual easement by necessity cases are rarer than hen's teeth. If you look back at the last 150 years of cases, they almost all, if not all, fall into the context of what we would now call an easement by implication. Up until about 15 years ago, there was no distinction between implied easements and easements by necessity. As of about 15 years ago, that distinction is recognized. Implied easements are based on an actual prior use. And if you look at the case law, almost all of these cases, whether they call themselves implied easements or easements by necessity, are in fact what we would now call implied easements. So it's a very rare animal, and to the extent it needs to be addressed, I would respectfully suggest that the common law has drawn the right bounds in making it difficult to prove. To the extent that I have any time left.
Well, you don't, but well, just one more question, then we'll move on to your brother or sister. Basically, what you are saying is that our current law is diametrically opposite to the restatement. The restatement essentially says that we will recognize easement by necessity unless where it is perfectly clear that that was not the intent, and you say that our law is that we should not recognize it unless it is perfectly clear that that was the intent.
I think that, I mean, there is a lot of the common law that is in accord with the restatement. They both, both the common law and the restatement require unity of title. They require that the necessity arise at the time of the severance. So that sort of the basics of it we all agree on. Where we part company is the common law of Massachusetts has been very clear in making it hard to create off-record rights. I would respectfully suggest for very good policy reasons.
Okay, thank you.
Thank you.
Thank you very much. Thank you. Morning, Your Honor. Diane Tillotson for the Martha's Vineyard Land Bank Commission. I'd like to just begin very briefly where Ms. Roberts left off and suggest to you that the difference between the restatement and the common law is that the common law creates a presumption in favor of an access easement for landlocked parcels, whereas the restatement essentially shifts the burden of proof and creates the presumption in the opposite direction. In other words, says that in order to establish that an easement by necessity does not exist, a servient estate owner has to establish that there was an intention to landlock a parcel. And I think that's the very clear distinction. I'd like to devote my time, and I realize how brief 5 minutes is, to drawing for the court the reasons that it is our contention that the common law presumption should not be applied in this case. That presumption, and I think what underlies this case, is that presumption has to be based on the presumed intent of the parties. And I'd like to, in order to illustrate my comments here, or my argument this morning, I'd like to ask the court, I think you probably all have the appellant's brief below, the big, thick blue brief, which also includes the record appendix. And I'd like to ask the court, if I may, to turn to pages 138 and 139 of that record appendix, which these are two sketches that were appended to the third amended complaint of the plaintiffs in this case. And I think they illustrate very well the principles of why the presumption that a presumption in favor of access for landlocked parcels cannot be applied in this case. The first of those illustrations, A138, is a close-up of A139. And A139 shows the multiple lots that are set out by this partition action. And as the court is aware, this is not an a transfer of a lot from one landowner to another, which is the situation in almost all the cases that this court and the appeals court have decided related to implied easements or easements by necessity. This is a partition of an entire town, the town of Aquinnah, 700 lots. If you look at on A139 for a moment, the lot that's marked 178 belongs to one of the plaintiffs in this action. The lots that belong to the defendants in this action, by and large, are located south of that lot, and it's fairly easy looking at A138 and 139 and comparing them to see where the land of the Vineyard Conservation Society, the town of Aquinnah, and the Martha's Vineyard Land Bank Commission. They're located south of these lots and also north of the Moship Trail. They're also located very close to the Atlantic Ocean. Respectfully, under the common law, and again, we urge the court to essentially follow the common law in this case and not apply the presumption here, because what you have is a situation where, first of all, the necessity, under common case law, the Schmidt versus Quinn case, the necessity needs to exist at the time of the original conveyance. There was no necessity here because there was a common practice of free access.
Now, is that a matter of dispute? That seems to have somehow become a question of fact that's unresolved. At least it seems to me from the reply brief or that there's some question about what the practice actually was.
Looking at the parcels that are laid out in these sections, I think you have to assume, consistent with the appeals court decision in Kitras 1 and Kitras 2 and the land court judge's decision, that there was a common right of access among all these lots. Because these lots, and if you look, I probably don't have time to call your attention to the specific, but I would suggest looking at E342 and 343 in the exhibit record, which indicates that those are a couple of the set-off deeds. Those are for house lots. Presumably, in order to get to those house lots, people had to have free access over these paths. And there's no, again, if you look even at the Schmidt versus Quinn case, and I realize my light is flashing, if you look at the Schmidt versus Quinn case, the pathway, the easement access has to exist at the time that easement is created. Otherwise, you cannot presume that the parties to this conveyance, and again, you have no servient estate here. There's no defined servient estate. The parties to this conveyance could not have possibly intended a labyrinth of pathways and easements to get from these landlocked lots out to State Road, which is the only road, if you see it on A139, that existed at the time of the set-offs in 1878.
So what's the point of creating all of these landlocked lots?
It was created pursuant to a petition to the probate court.
What's the point?
The point was so that people could have ownership of their single house lots.
But couldn't get access to them?
They could get to them because at the time, no,
Yep.
excuse me?
Helicopters?
No, at the time of these conveyances, and the land court judge recognized this, found this as a fact, at the time of these conveyances, it was common practice and custom to allow free right of access over the land of other tribe members.
Seems so counterintuitive that you have this right of access under a common custom that we presume is the case, but that the amicus brief on behalf of the indigenous people themselves say is not common, that they have that, and because of the structure of the way the property was transferred, it can't be recognized any longer because it doesn't fit within our construct of how these kinds of easements are created. Maybe it just needs a new construct. if it doesn't fit?
That-
Because it doesn't seem to.
I would not disagree with that, but I would suggest to you that it also appears counterintuitive when you look at A139 to assume that the commissioners intended to create access routes over all of these lots. They did it in Chappaquiddick. It's interesting that they did it in one location but not in another. I realize that they were different commissioners, but obviously they all had knowledge of what each of the other commissioners were doing. And I would suggest that it would have been relatively easy to construct a grid in a way that accommodated access roads. And the commissioners clearly did not do that, although they did create access rights to get to peat areas.
I don't want to take your time, but just the point that it may have not been consistent with how the custom was in order to access those properties. It may that have been a superimposed European custom of grid and access. But anyway, just.
And that may be true, and I would just note also that the deeds, the individual severalty deeds, which are included in the record, usually have descriptions that bound on stone walls, so they were clearly carefully thought out when they prepared this.
So
Your view is that if somebody is a descendant of the Gayhead tribe, they have free access over all these properties?
I'm not sure that that's necessarily the case, Your Honor, because
And
I
what
think
is
that
this?
those
I thought you
rights.
said that tribal access was understood as part of the,
It was in
if I give my Gayhead, I'm a member of the Gayhead tribe, I can just walk on, but if I'm not a member of the Gayhead tribe, I can't.
I think that in 1986, if I'm not mistaken, and
Extinguished.
that those rights were extinguished,
Okay.
if not prior to then.
All right, and was there any, all right, so and so part of it, the implication is that the commissioners anticipated that this would forever be owned by the Gayhead tribe members, that it would never be sold to anybody who was not a tribe member? Was that the understanding at the time?
It's hard to say what the commissioners were thinking. I would respectfully suggest that given the way these grids have worked out, the commissioners probably thought that the right of free access would continue, and at some point, the tribal members may, in fact, as a tribe, establish roads. But of course, presuming, again, it's very difficult because, of course, this was in 1878. I think presuming any intent, but certainly presuming an intention to create a right to go south to the Atlantic Ocean is not only counterintuitive, it really is beyond the scope of what the commissioners could have imagined, let alone intended in 1878.
Can I just ask, when we talk about the parties and the party's intent, who are we talking about in terms of the party on the grantor side? Is it the Commonwealth?
Well,
Is it the commissioner? Whose intent are we looking at?
That's a very good question, Your Honor, and obviously the enabling legislation was the Massachusetts legislature that acted to essentially create the town of Aquinnah and to provide a means by which the inhabitants could petition the probate court. The probate court would appoint commissioners. But I would suggest that the commissioners themselves, and not the legislature, were the fact finders, and it was the commissioners that were the, quote, parties, although you will note if you look at the deeds or the set-offs in the record, there are no grantors listed per se. I would suggest to you that it's the commissioners because it's the commissioners that drew out these detailed descriptions of the lots.
But they were different commissioners for different tribes.
They were different from the Chappaquiddick commissioners, yes. The commissioners were appointed by the probate court.
So in other words, we can't really look to that then. If we're looking to the commissioner's intent and they're different commissioners,
I would suggest that you can look at the facts and circumstances that existed at the time of the conveyance. And at the time of the conveyance in 1878, these commissioners would have been charged with the knowledge of what the commissioners in the Chappaquiddick set-off had done.
can I ask you, how do you characterize this type of tribal access in terms of the common law? Was it something that was analogous to a personal right of access versus an easement in gross? Why doesn't it continue to exist even after the federal extinguishing?
I am not certain whether I would characterize it as a personal right or an easement in gross, but I would also suggest to you that I'm not sure that it was ever raised or ever argued that there was no right of access on foot by tribal members to reach these lots. And I'm not necessarily sure that that point would be argued the way, if you turn the page 1 to 140 and see this 40-foot proposed layout that has been suggested by the plaintiffs in this case. This is a vehicular access roadway. Again, tribal custom and the custom of the Wampanoags clearly was access by foot. That was not examined
But I mean,
below.
they may have needed a cart, they may have needed a
Certainly.
donkey or a horse or something like that, and so we've replaced all those things with cars.
And I understand that point. I'm not certain as to whether I would characterize this as an easement in gross or as an appurtenant permission, almost. For me, or the way I analyze it, it's almost akin to a permissive use that was incorporated into a tribal custom. But once the tribal members no longer owned the parcel, once the permission and the tribal custom ceased or was abrogated by the act of the Congress and the legislature in 1986 or 7, I think that those rights ceased. Again, no one has argued or tried to argue that there isn't some tribal customary right, and certainly the tribe also submitted an amicus brief in this case, as the court knows.
All right, thank you.
Thank you very much.
Good morning, Your Honors. Ronald Rappaport, Town Council for the Town of Aquinnah. Justice Lank, going back to your question, in 1870, when the Massachusetts legislature passed the act authorizing creating the town, they conveyed all the lands in the town to the town and allowed for permission, for partition. That partition happened in 1878 by the commissioners, as you're well aware. The commissioners reserved rights, they reserved peat rights, they reserved herring rights, and they said they did their work carefully. So as of 1878, the parties were the town, the tribe, all the residents of the town in 1878 were tribal members. The Commonwealth, because the legislature had passed it, and the commissioners. We then have 100 years of real estate conveyances with hundreds of title passing.
When did it start getting passed from tribal members to non-tribal members?
I'm sorry?
The conveyances begin from tribal to non-tribal members.
I'm not sure I can, it would
roughly.
be shortly after 1878. I mean,
Shortly after.
by 100 years later, there were numerous parcels that have been conveyed because those people were all parties to the subsequent litigation in federal court. So we have 100 years of real estate conveyances happening.
And were those conveyances made to non-tribal members?
Oh, absolutely. You know, hundreds of 100 years of real estate, 100 years of real estate conveyancing.
There's no issue of adverse possession here?
There was a claim of adverse possession, but it was dropped in this case. So no, there isn't. There was only one road in the town in 1878. It went from State Road from Chilmark to the end of Aquinnah. So what happens, 100 years later, we have the tribe filing a lawsuit claiming that the set-off was invalid in 1878 because of the Federal Non-Intercourse Act. Who'd they sue? They sued the town, they sued the tribe, they sued the Taxpayers Association, which was a group of homeowners. That case went on for 9 years and was settled by a settlement agreement among the parties, which eliminated all claims of title. And cleared title, and this court has set out the history in the shellfish hatchery case 443-1. So we have a settlement agreement which clears all the title. We have the Massachusetts legislature acting in 1985, ratifying the settlement agreement. We have Congress acting in 1987, ratifying the settlement agreement, eliminating all Aboriginal claims back to 1987 and clearing all titles back to 1987. And I think the language is important. Let me just read you a sentence. It says, the pendency of the federal lawsuit by the tribe, the 1974 federal lawsuit, has resulted in severe economic hardship for the residents of the town of Gay Head by clouding titles to much of the land of the town, including lands not involved in this lawsuit. So in 1987, with the Congressional Act, 110 years after the set-off, we have clear titles in town and all rights, Aboriginal rights, wiped out. So the parties who've been involved in that time with the Massachusetts legislature twice, the commissioners, Congress, the town, the tribe, and the taxpayers, the homeowners. And do you think all of those people missed this issue of easement by necessity? We had clear title in 1987. We now jump, this lawsuit's filed in 1997. 20 more years go by until the appeals court rules, and now 140 years after the set-off, we have the same issue with uncleared titles in town.
What does that go to? Does that say that everybody understood that this was the intent, or is it your view that even if that was not the intent, it doesn't matter because history has passed it by?
I think we have to look at, and the case law says so, you look at the conduct of the parties subsequent to the conveyance, which would be the 1878 partition. You look at the conduct of the parties and see how the parties acted, and all this land was conveyed. All these legislative bodies acted.
Okay, and going back to that, do you agree with your sister that the parties in this case are the commissioners?
It's a very unusual case because we have a partition of an entire town.
Right.
So the party which set off the land obviously was the commissioners pursuant to an act of the legislature and set off land that was conveyed to the town in 1875.
And is it the commissioners' intent we need to discern, or were the commissioners acting as fiduciaries on behalf of the tribe?
I think the commissioners were acting as fiduciaries on behalf of the legislature because they were charged by the legislature with doing the set-off.
But who owned the land? But it was owned by the town at that time.
It was owned by
correct?
the town at that point. Absolutely.
And the town agreed to the partition.
Pardon?
The town agreed to the partition.
The town had no choice but to agree to partition because the 1870 legislation mandated it. I'm not saying this was a consent issue, no, but that's the way the scheme.
So it was conveyed to the town in this gross fashion, right? I mean, it was this combined huge lot. But it was almost on condition that in the event that the inhabitants wanted it partitioned, that it had to be partitioned.
That's correct.
So it was almost a conditional conveyance.
I would absolutely accept that characterization. That's correct. So here we are in 2015, 140 years after the conveyance. Every lot in town, whether it's vacant, whether it's built upon, whether it's registered, whether it's unregistered, whether it's owned by the town, the Commonwealth, conservation land, is subject to a springing easement in favor over their land, and that's simply not an acceptable result. The plaintiffs argue that they're one lot. Well, look, we're one lot away.
I'm sorry, it's not acceptable because it produces some uncertainty, I understand, but I mean, wouldn't the land court identify what would be an appropriate easement, which would be respectful of the property rights of those whose property is being burdened?
Well, in effect, you're wiping out 140 years of real estate activity in the town and creating a cloud of title on every lot in the town.
How long would that cloud last? It would last until the land court resolved it, wouldn't it?
No, because the land court is only dealing with these two parties. This decision, if you come down against, if you don't reverse the land court, you're subjecting every parcel of land, and registered or unregistered, I'll go back to it, every registered or unregistered, to a potential of having a road located on his property. These plaintiffs are only two. This case would have implications throughout the entire town. And I'll just briefly wrap up. I know my lights are going. I'm trying to go as fast as I can in my 5 minutes. They say they're only one lot away. Just look, we can get to Motion Trail over these two lots. Those lots are owned by the town and the Commonwealth. The lot that's owned by the town is subject to a conservation restriction because it was purchased in cooperation with the Commonwealth, who's here today, and they've authorized me to speak on their behalf. and the other lot is Vineyard Conservation Society, and that was purchased for conservation purposes. And the road goes to Moship Trail, which didn't exist at the time of the set-off. So being one lot away is just totally misleading. What I'd say is, let me just briefly address the tribe. The tribe filed an amicus here. The tribe does not argue. It's significant. The tribe does not argue that there's an easement by necessity as a result of this 1878 setup. They don't argue that. They just say, send the issue of custom and usage back to the tribal court to adjudicate. Well, first, they said to this court in the FAR back in, from the Kitras 1, that this court doesn't have jurisdiction. None of the Massachusetts courts have jurisdiction over the tribe. And also, well, I'll move on. There's not one case. There is not one case out there. We've said that in our brief. There's not one case out there where a division of land of an entire town, over 700 lots, there's not one case that says that there would be an easement of necessity in that situation. So you'd be breaking a totally new law here if that was the result. I think the land court got it right. I think Justice Agnes got it right in his dissent, and the implications on the town and the taxpayers and the property owners would be absolutely significant if this case, if the decision of the land court was not upheld.
Thank you.
Thank you.
Good morning, Ms. Sibison.
May it please the court. I'm Wendy Sibison. I represent the Kitras and DeCoulis plaintiffs, and my sister Leslie Morse represents original grantees' descendants, and she will speak for a few minutes when I'm done. Before I get started, I want to clarify that the final judgment in this case is in the supplemental appendix, not where I said it was in my brief. I fixed that later, so it's at the beginning. A question was asked about who was the actual grantor in this case, and it's of course of interest. The actual grantor was the probate court that ordered the lots that had been divided by the commissioners under orders of the legislature should be created on behalf of the tribe. I think the best answer here is that the grantor, whoever it was, whether it was the probate court, the commissioners, or the legislature, were acting in a fiduciary capacity on behalf of the tribe. That's because this statutory scheme was part of a historic effort to restore long disenfranchised people whose land had been expropriated from them with no participation by them except violence, to try to restore them to the status of humans and citizens in this country.
So are you saying basically it's the tribe that conveyed it to tribal members?
No, I'm not. The probate court, the tribe petitioned to partition the land
Oh,
as...
I know, but you just said that they were acting as fiduciaries for the tribe. So if they're acting as fiduciaries for the tribe in some real sense, then the tribe was conveying the property to the tribal members.
Yes, but the only reason that happened is because the legislature allowed it to happen, and everyone was acting pursuant to that statutory civil rights scheme. So it's a little hard to pin down who was the actual grantor, other than to say this was a petition to partition a large lot of land that was held conditionally by the tribe. I don't know how to make a better answer, but one can. So given the fact that the intention was to create alienable lots, and by the way, that was the intention of the legislature here. This court in 1871, in Danzel versus Webquish, 108 Mass at 134, clearly stated that the purpose of these statutes was to allow the Native American people to alienate land. That was considered a fundamental part of the bundle of rights of citizenry that was being created here, the right to alienate land.
Alienated to other tribal members?
No, outside the tribe. They could already sell it to each other.
They could.
Yes, well, their possessory rights could be conveyed to others. Until all these transactions, they had only possessory rights. They didn't.
This is tribal.
Yes, this was under tribal law. Possessory rights could be conveyed to another Native American.
How?
But title could not.
How would those specific?
I don't know how it happened. No idea. But in James versus Watt, I think there's a lot of that, the First Circuit case, the way that worked is at least discussed to some extent. But there was no power to alienate property outside the tribe. And this is one of the things that the legislators and the commissioners discussed in the reports here. That
Where
this
did
was
the evidence of the common custom and practice come from? That so much that it's tied up into so much of this case about free access. Where did that evidence come from?
I don't know, Your Honor. I have scoured the record, and my sister filed a brief where she refers to the few pages in the record where it says anything about common access. And all it says is that people use the common land in common, but when people had separate lots, the severalty lot, and my sister herself quoted it at page E231, it's the only reference to how the people treated the severalty lots, the ones that had been enclosed, like the ones that were created in this transaction. They were all separate lots. No one intruded on those lots.
But if this is an important fact, I thought this all went to the land court judge on the basis of a settled record, well, basically the documents. And
A settled record, but not an agreed statement of facts.
So there was no testimony offered, nothing before the judge on this, and now all of a sudden we've got a contested issue of fact that looks like it's material?
Yes. The review is de novo in this court, factual and legal.
Are we supposed to send it back for more proceedings?
No,
To
I don't
settle
think so,
those-
Your Honor. I
to
think
settle-
that it's de novo review by this court. The thing is, okay,
But how do we
It
know?
is a
How do
contest-
we know what it is, though? I mean,
you have the whole record.
Yeah, but
but
it's
if
not in the
it's not
record.
there, if
That's right.
so.
Assertions were made, and over the years of this case, eventually they were said enough so that somehow this finding that started out referring only to the way the Indians used common land, somehow the severance lots appeared in that same sentence. It's just nowhere in the record.
Does the record indicate that there's any contrary view about this?
The severance lots?
Yeah,
No.
or about this tradition of.
No. No. The record is very.
The record only shows that there is some affirmative evidence or a
Yes.
statement that there was a tribal custom that permitted free crossing of these lands,
Of the common land.
of the common lands.
But did not permit free crossing of the separate lands. And separate lands is what we got in 1878. Everybody had their own parcel. And according to the record, and the only place it's even mentioned is at E231, no one intruded on a person's separate parcel.
But weren't these common lands, even after the partition?
No. No, partition divided up every bit of the common land that is an issue in this case into separate parcels. There was no more common land across which one could walk.
What do you say to the argument just made that if the appeals court judgment stands, literally the titles of all of these lots, every single lot is in question?
Well, what's not in the record is how many lots would be affected by this court's decision.
Well, this
You can
court's
look at a
decision,
map and
however,
see
would
these
set wouldn't this court's decision, however, set a precedent for the assertion of similar rights in other lots?
Yes, other people have brought claims and actually won in land court based on these exact same transactions. This is not the first case that's been raised in the land court around the 1878 transactions. You've actually got, I gave you those, they're part of the record. They're in the appendix. So this isn't actually a novel question. It's a question that's been going on for 40 years now in the land court.
And we've decided before?
No, it's never gotten past the land court. But getting back to the question of custom and practice, let's pretend that it's in the record, which it isn't, that these people used to cross over their separate parcels. Still, all they had was, as my sister acknowledged, permissive use, which is not a legal right of access that can be transferred. So the law of easements by necessity is based on the common sense, logical proposition that where parties divide up one solid piece of land, they intend the grantees to have a legal right of access. That's what you need to alienate property, and that's what these Indians needed in order to alienate these otherwise landlocked lots. They needed a legal right of access. They didn't need permissive use that couldn't be transferred to anybody outside the tribe.
So whose lots are now going to be subject to access roads?
Whose lots?
Yeah.
Well, in our case, 2 lots. 2 lots right next to the Moship Trail. One owned by the town and one owned by Vineyard Conservation Society, and we only need one of them to get total access to all our lots. So that's the facts in this case.
May I ask you about the appeals court opinion, which starts with the proposition that the judge says we have the equivalent of a chain of title.
Yes, I don't agree with
What
that.
does that mean?
It's not anything we ever argued, Your Honor. I don't want to be rude and distance myself from it, but we never argued it, and I think it created a lot of confusion, and it probably made a lot of sense for this court to take this case for that reason alone. There's no some sort of freestanding easement based on Indian ownership. We have always only relied on the law of easements by necessity, and we've relied on 3 common sense propositions. First, the law. The law of easement by necessity is based on the common sense logical proposition that parties intend grantees in conveyances like this to have a legal right of access to their land. And that's just simply common sense.
What would that have been in 1878? It couldn't have been the easement that you're now seeking.
I'm sorry?
It couldn't have been in 1878 access to south, to the Moship Trail, which didn't exist, right? You're
That's
saying
right. That's
the only
right.
it could have been was north, but you're not
Yes.
seeking to go north.
Well, so that's,
Haven't sued the owners of the lots.
we
that
don't
go
have
north.
to go to the Moship Trail. We could go a much more elaborate, more intrusive route. The Moship Trail leads to State Road, which is the road that existed then, but the law on easements by necessity, unlike the law of other easements, are the way that you're seeking access to didn't have to have existed at the time the easement arose. It didn't have to be on the ground. You just get it when you claim it.
But what
It's
if one
appurtenant.
What if one of the other lot owners wanted to go across your client's land to gain access? Is it a question of who gets there first, who gets to the courthouse first?
I don't think so. I think just locating the easements on the ground is always a case.
But it's always going to be over somebody else's lot.
Yes, it will. Yes, it will. If the parties wanted to engage in some very intelligent planning, that would be a good thing. But that's not an issue that we have to address. And the number of lots in issue is not catastrophic, but I'm not going to speak outside the record.
Where does the 40-foot easement, where's the 40-foot size come from? As
Oh, you mean
opposed to
that's
a trail?
proposed on our map?
Right.
I don't know. It's just a proposal to show what would work for us. Maybe it has to do with zoning laws in the town. I really don't know, Your Honor.
So all these lots were conveyed over the years, since 1878, to non-tribal members.
Well,
and
how
what-
many
like
that is not in the record, and I don't.
Well, yes, but I mean, it's sort of like this big gaping hole in the record, too, I mean, what happened to the land in that period of time, and how is it possible that no one who bought the land wanted to know about this easement? How do they get access to these lots?
The development of this area is pretty complicated, but, the Moship Trail got put through, so that gave people who didn't have access before easement. Another road got put through, that gave people access. Many of the owners were very, very poor, who couldn't afford to litigate this issue. So, I mean, it's a complicated question, and plus, land preservation organizations, such as those sitting here, bought up all the land that fronted on the Moship Trail in order to prevent development. So that's a complicated question, Your Honor. I wanted to, if I may, get back to the other 2 common sense logical propositions other than the law. By the way, the law of the restatement is not grounded largely in public policy. It's grounded on that common sense proposition that people don't intend to create landlocked parcels. So, and that's what the restatement says. It's very clear. The other 2 propositions that are common sense is that the legislators, with explicit intent to create alienable parcels for these formerly disenfranchised people, did not intend to give them landlocked lots. That would have been brutal. That would have been one more insult on the history of this country. That's common sense proposition number 2. And common sense proposition number 3 is that the people who petitioned to turn their common land into a bunch of parcels, looking for the protection of the common law title, which they'd never had before, somehow didn't intend that they would have common law access. That makes no sense.
So why didn't they create roads? Why didn't the commissioners create roads the way they did in other parts of the town?
That's a good point. They did create roads. They expected these roads to be used, but they left out access.
In this particular area?
In this particular case, they created or improved a road that ran right through the land. That's right. But as far as Indian access is concerned, nowhere in the relevant reports surrounding this historic civil rights legislation is there any mention anywhere of the fact that these people used their common land to cross common land. It's just not mentioned.
Now, one of the briefs, I think, argues, or at least Justice Agnes in his dissent made the point that in these other areas where commissioners had partitioned the land, they included roads. Here, they did not include roads.
I think there is a road here. I think it's in the 1870 statute,
Yeah,
1871 statute.
but it doesn't provide access to all the lots.
No access. Well, in the first place, I don't think in Mashpee
But the point that he was making was
Yes.
that if there were roads that provided access in other acts of partition, and there were no roads, or there wasn't partition activity that created access to all the lots in this area, the suggestion is that there was a tribal custom that allowed free access over all of these lots that are in this area.
Well, in the first place, a road was created here. And it's hard to imagine that the legislators intended that only the people who had frontage on that way would have usable lots. And second place, the rule of law is not to speculate what was in people's minds. You need clear evidence that they intended there be no legal right of access. That's the law of Massachusetts, Davis versus Sykes, and that's the law of the restatement. There has to be clear evidence that no access was intended. And the case in Massachusetts that's about that is Orpin versus Morrison, which has all the bedrock law, except for in that case, there was evidence that the parties said to each other, we're not going to have any access here. That's clear evidence. That satisfies the restatement's rule. This is such a powerful rule of law throughout the centuries that this court and other
Statement rule or our common law?
both. This rule of law is so powerful over the centuries that it trumps a warranty deed. It is a powerful appurtenant right that is created the minute the transaction happens and an otherwise landlocked parcel is created, and it runs with the land. It's a powerful, logical, fair rule of law that no one has had the resources until now to try to actually stand up and fight for.
All right, thank you.
Thank you. And I would also ask the court to please rule on our Lot 178 so that we don't have to prolong further litigation. Thank you so much.
Good morning. Good morning. I am Attorney Leslie Ann Morse, and I represent Mark D. Harding, Charles Harding, and Sheila S. Bessie, as they are the trustees of the Eleanor P. Harding Realty Trust. I represent the Native Americans in this case, although they are members of the Mashpee tribe, not of the Aquinnah tribe. Lot 555 was given to their ancestor, Aaron Cooper, out of the original set-off in 1878. So it has always been ancestral land. Now, for a few questions that were asked as to whether or not easements possibly would go over some of our land, the answer is yes, because the logical way to bring an easement down from the lots to the north is across 554, and there is already an easement from 555 to lot 554. So it encompasses our land, we understand that. And there's been a lot of talk about rights of access. If you look at even what the tribe filed for the amicus, those rights were over the common land. Yes, they went back and forth because almost all of this land was common land. However, all Aboriginal rights ended in 1878. So that's common rights, even if they existed at that point, were gone. And I'm really glad my sister brought up the appendix, page 139. Look at it. The legislature set up the town of Aquinnah, a town of Gay Head at the time. How were you supposed to go anywhere? You had, maybe a few dozen lots that were on state highway, but not the majority. The great, great majority were landlocked. I can't believe that the legislature intended that, and I can't believe they intended to give my people land which they couldn't access. And, over the years, Aquinnah was poor, and there weren't very many people there. And as it became more and more popular, obviously people have moved into it, and people have made efforts to preserve it. But that doesn't take away our rights to access our land.
How have you been accessing it for the last 130 years? How have you been accessing it?
I don't think they really were. I mean, until they put in Moshop Trail, it would have been extremely difficult.
There was some language describing these lands as rough and uneven and suitable for nothing other than pasture land and perhaps for berry picking. What do you say about that? I mean, were people building houses on this area?
Not at the time, because there was no public way to get down there until they put in Moshop Trail. I do believe that Pease, who probably was the commissioner who was more familiar with the land, did say there was a little effort that it was good farmland. You could farm it. And that's basically, the natives used it for farmland, and they also used it for pasture, because that they could rent out and make money on.
And is there evidence in the record that indicates that that was in fact done after 1878?
I don't think it was done after 1878, because by that point you have divided up the lots and everybody has their little parcels, which they can't get to because nobody gave them any rights. And as for pursuing it, these people were poor. I represented Eleanor P. Harding, who died during the pendency of this litigation, for over 20 years. And she and I would look at the lots she owned. How do you get to them? And in a couple of cases, it meant taking on one of the wealthiest and politically connected families in the country to get to her lot. There was no way she had the financial resources to do that. So, we've come along with the Kitras people to say, come on, we're entitled to access to our land. Thank you, unless you have any questions.
Thank you.